Hi, this is Chris McKaylee of Glossary of Terms. This one is for the judicial branch of California state government. And I put this list together for those who work around the California state capitol. Obviously, it's not a thorough legal glossary of terms. I mean, you have things like Black's Law Dictionary, which has thousands of words and phrases and terms used in litigation and in the legal community and by the judicial branch. So these are ones that I think folks operating in the legislative and executive branches should be aware of. Acquittal. It's essentially a release from any civil liability. In the criminal context, it's a finding of not guilty. Adjudication is a judgment having been made in a case. Admonishment, when a judge makes a statement regarding the conduct of a lawyer, litigant, or juror. Affidavit is a written statement of facts made under oath. Alternative dispute resolution, or ADR, a means of settling a legal dispute without a formal trial, including mediation and arbitration. Amicus curiae, this is a Latin term that means friend of the court, and it refers to a party that files a legal brief even though they are not an actual party to the lawsuit. Answer. This refers to a civil defendant filing a response to the civil plaintiff's complaint. Appeal. This is a formal request to a higher court to review a legal decision made by a lower court. Appearance. An action by a party to a lawsuit who makes a personal appearance in a court of law, generally by an attorney for that party. Appellate court or appeals court, a higher court that reviews a lower court's decision. In California, there is the Court of Appeal, the Intermediate Court, and then the Supreme Court, which is the High Court of the land. Arbitration is a form of ADR that's used when two parties use an independent arbitrator to decide a legal dispute. Arbitrator. This is an individual chosen by litigants to hear a case in arbitration and to make a binding decision, often a retired judge. Bar. This refers to an association of lawyers. A bench trial. This is a trial before only the judge, not a jury. Beyond a reasonable doubt. A phrase in criminal law that specifies the standard of proof required by the prosecution in order to obtain a guilty conviction of the defendant. A brief. This is a written document submitted by an attorney in a case, including statements of fact, legal arguments, etc. Burden of proof. In a civil or criminal case, this is the standard by which a party must meet in order to impose liability on the other party. Rules of court, or California rules of court, these are the rules that regulate practice before superior courts in the 58 counties, as well as the 6 courts of appeal and the Supreme Court. Case law. This is the law as established by written decision of California's appellate courts. Judicial decisions, it's also often called the common law. A cause of action is the basis for a party to seek legal relief in court. Certiorari. This term refers to when a reviewing court agrees to exercise its discretion and review a lower court's decision. Challenge or challenges. There is the ability for a judge or attorneys to dismiss individual jurors from serving on a jury for different reasons. An attorney for a party will challenge a juror's service and explain the reason for doing so. There are so-called challenges for cause and peremptory challenges. What's a challenge for cause? This means there's a justified reason, such as a family or professional relationship with a litigant, to excuse the juror from service in a particular case. There's generally not a limit on the number of for cause challenges. A civil case or a civil suit. This is a lawsuit that's filed in civil court, not criminal court, to resolve a legal dispute and often seeking monetary damages. Common law. This is the law as established by written decisions of California's appellate courts. They're written judicial decisions. Common law is also called case law. Controversy. This refers to a legal dispute between parties. Class action is a civil lawsuit brought by one or more persons on behalf of a larger group of individuals who have the same cause of action. Closing. This could refer to either the conclusion of a legal transaction, most often associated with a real estate or a contract transaction, or it could refer to the final arguments made by an attorney at the conclusion of a jury or bench trial. Compensatory damages. This is a monetary award to cover actual cost to a party, including things like lost wages or property damage suffered. Concurring opinion. This is a written decision by those justices who agree with the majority's decision, but they do so for one or more other reasons. Contingency fee. This is a legal fee arrangement by which an attorney is paid a specified percentage of a financial recovery. If there are no damages awarded, there is no fee. Copyright is the right to preclude others from using another's work. Counterclaim, a claim that is filed in a civil lawsuit by the defendant against the plaintiff who's already filed their claim against that defendant. Counsel is another term for lawyer or attorney who represents a client in legal matters. A criminal prosecution or a criminal case. This is when the state of California charges an individual with a crime, a violation of the penal code. There are three types of criminal cases: infractions, misdemeanors, and felonies. Damages. This is a monetary amount awarded to a party in litigation. Default. This occurs when a defendant in a case fails to file a response to a complaint or fails to appear in court. Degree of proof. This is the standard of proof that's required for a civil case, such as preponderance of the evidence, or in a criminal case, most often beyond a reasonable doubt. Deposition. This is the taking of sworn testimony by a witness. Disbarment, when an attorney in the state is removed from the bar and cannot practice law in the state. Discovery. This occurs prior to a trial, and the parties to the case obtain information from the other. This occurs in discovery. Dismissal with prejudice. This occurs when a case is dismissed for a valid reason and the plaintiff is prohibited from bringing another case based on that same cause of action. Dismissal without prejudice. This occurs when a case is dismissed for a valid reason, but the plaintiff could in the future bring another case based on the same cause of action. Dissenting opinion. This is a written decision of those justices who disagree with the majority's opinion. Due process. From the federal and state constitutions, this provision protects an individual's right to life, liberty, or property without due process of law. Equal protection clause, or equal protection. From the federal and state constitutions, this provision protects individuals from discrimination by governmental entities. Evidence is basically proof under the law set forth in a legal proceeding, such as from witness testimony or written documents or statements. Expert witness. This is an individual with special skill or knowledge of a subject matter who's allowed to testify based upon that knowledge, even if they were not a party to the matter. Expungement is the term used to describe when a criminal defendant's record is eliminated. Felony. This is one of three types of criminal offenses and is the most serious one and generally requires imprisonment of a specified time period for that offense. Felon is the term describing an individual who is convicted of a felony crime. Fiduciary. Either an individual or an entity can be a fiduciary, which means they're legally responsible for monies or property owned by another person or entity. Grand jury. At the county level, this is a group of citizens who brought together in order to hear a criminal prosecutor's evidence and whether probable cause has been shown to prosecute somebody for a felony offense, an alleged felony offense. Guardian ad litem, a Latin term that means guardian at law, who's an individual appointed by a court to protect the interests of another person, usually a child. Hearing. is a term that refers to a formal legal proceeding, but also refers to official proceedings conducted by the legislature or sometimes the executive branch administrative agencies. Impartial. This means the maker is working without any bias or predisposition regarding a legal proceeding, such as jurors or a judge. Instruction. This term describes an instruction given by a judge at the start or conclusion of a trial for the benefit of the jurors who are considering the facts of the particular case. Injunction means an order of a court either prohibiting or requiring something to be done or not done. Interrogatories. These are formal written questions that are given to a party to a lawsuit or a witness to answer as a party of discovery in a legal matter. Joint and several liability. This is a legal doctrine that makes both parties financially responsible, that is, liable for the total amount of financial damages awarded, even if the other party cannot pay. Judgment is a decision of a court of law. Jurisdiction describes the legal authority of a court to consider a particular legal matter. Litigants are the parties engaged in a legal dispute. Majority opinion is the written decision by a majority of the justices deciding the appeal or the matter. Mediation is a form of ADR which involves a neutral third party who tries to bring the parties together and mediate or settle the particular legal dispute. Mistrial is when a serious error in a trial occurs. A judge can declare a mistrial and the trial will have to start anew. Moot is a legal matter is moot when an issue that is no longer able to be resolved because the case itself has been resolved. A motion to dismiss that is used in a civil case where the defendant claims that even if the plaintiff's claims are true, there's no legal relief that's available to the plaintiff, and so the judge should dismiss the case. Negligence is a legal doctrine that imposes liability when reasonable care was not used under the particular circumstances. Oath is a legal pledge made by an individual, such as to tell the whole truth as a witness or a juror. It's also an oath of office made by an elected or appointed official. Opinion refers to a judge's or justice's written decision in a case. Per curiam opinion is a written decision of justices that is unsigned by the court majority. Per curiam means for the court. Perjury is the giving of a false statement made under oath in a legal proceeding. Petitioner generally describes the party who's appealing a lower court's decision. Plaintiff is the term used to describe the person who files a lawsuit or brings a legal action. Plea. This is the answer to criminal charges that is made by the defendant in court as to whether the defendant is guilty or not guilty, or no contest is being pled. Pleadings. These are the written legal arguments and statements of fact that are submitted by the parties to a lawsuit. Postponement. This occurs when a legal case is rescheduled to a different time. Preponderance of the evidence. This is the legal standard or burden of proof used in the civil case. Pro bono or pro bono publico. This is the Latin term that means for the good of the public, and it's used to describe free legal services provided by an attorney. Pro se is a Latin term that means for himself. It's used to describe when an individual represents himself or herself in a legal matter. Reasonable doubt is the legal standard or burden of proof used in a criminal case. Reply describes the written response provided by a party to statements made in a pleading by the other party in litigation. Respondent is the term generally used to describe the party against whom an appeal is taken. Retainer is the term used to describe the fee that's provided by a client to an attorney upon beginning the attorney-client relationship. Sequestration is the term used to describe when a jury, all the jurors in a single case, is required to stay together and is precluded from interacting with other persons until the trial is concluded. Standard of proof is the burden that a litigant has in proving their case, such as in a civil case, the standard is either a preponderance of the evidence or clear and convincing evidence. Standing is the term used to describe a party's legal right to file a lawsuit in court or bring an action. Statute of limitations is a statute, which places a time limit on when an individual must file a particular cause of action. Stipulation is a term referring to when there's an agreement between the parties in a legal matter. Subpoena is a legal order issued by a judge that forces an individual or an entity to either appear as a witness or to produce specified documents. Summary judgment is when a court issues a legal determination that the facts of the case are not in dispute by the parties and that one party is entitled to a judgment as a matter of law. Summons. This is a legal document that instructs an individual that he or she must appear in court. A temporary restraining order, or a TRO. This is a temporary legal order from a court that stops someone from doing something when, for example, an immediate loss could be suffered. Testimony describes when a witness appears under oath and provides testimony about a case. Tort is a civil wrong for which the law provides a remedy. Unanimous is the requirement when an entire jury in a case decides on the same verdict. Venue is the term used for the legal authority of a court to hear a case based upon its location or power over an individual or matter. Verdict. This is a decision by the judge or a jury in a civil or criminal matter. Voir dire. This is a French term that means to speak the truth, but it actually refers to the process used by either the court, the judge, or attorneys to examine prospective jurors in a case to determine whether they will be unbiased in their deliberations. Witness is an individual who gives a firsthand account of an event that they saw or heard. A writ is a judicial order directing a person to do or not to do something. A writ of certiorari is a written order issued by the Supreme Court requiring a lower court to send the case to the higher court. A writ of execution is a written court order that is used to take money or property to satisfy a legal judgment. Now, as I mentioned at the outset, there are many other legal terms and phrases used in the practice of law in the state. You can look, for example, at Black's Law Dictionary and its thousands of legal terms and phrases and words. So this glossary is intended to provide definitions of many of the words and phrases that you might want to know if you're involved in the legislative and executive branches of California state government.